Well, welcome back to the Cordell and Cordell Virtual Town Hall. As usual, I'm your moderator, Scott Trout. I'm also the CEO and managing partner of Cordell and Cordell. We continue to bring you these virtual town halls and a group of Cordell and Cordell attorneys from around the country, as we've done this during the COVID pandemic for nearly over 200 days now. So we're going to continue to do this moving forward to bring you the latest information. But as I always start out my podcast and the virtual town hall, make sure you understand this is not legal advice. The things that we're going to talk about really are just our collective experience, comments in terms of what we can do. Generally, we really encourage you to go seek out a consultation with an attorney who practices exclusively in family law, like we do around the country. We have offices throughout the United States, including the United Kingdom in central London. So if you have questions or you want a consultation, you can reach us at 866-DADS-LAW. You can log on, go to CordellCordell.com, get more information. We can do it via Zoom just like this. We can do it on the phone. We can also do it in person where appropriate and we're allowed. We want to keep health and safety in mind. So go ahead and give us a call, 866-DADS-LAW. As we do each week, we encourage you to submit your questions during this virtual town hall utilizing the chat or the Q&A section in the Zoom technology. So do that now. We're getting some questions as we go, but make sure to do that early. We'll move to our Q&A section in the second half of today's virtual town hall. If you have a question and you'd rather just have us address it later in a podcast, which we do twice each week with Cordell and Cordell attorneys, you can send those to coronavirus.divorce@cordelllaw.com. That's coronavirus.divorce@cordelllaw.com. So let's go ahead and introduce our panel today from around the country. We're going to start in Birmingham, Alabama. David, welcome.
Thank you. Glad to be here. Again, my name is David Thomas, and I am in Birmingham. I've been working for Cordell for 3 years and practicing law for 10 years. And I'm excited to answer any questions that you guys have and see what we can do to help out.
Thanks, David. Let's go to Scottsdale, Arizona with Tally Collins. Welcome.
Thank you for having me. My name is Tally Collins. I'm the litigation manager based out of our Scottsdale office. I've been practicing exclusively family law for 12 years now, and I've been with the firm a little over 5. So thanks for having me.
Thanks, Tally. Let's go to Baltimore. Let's go to Ashley. Welcome, Ashley Ward.
Hi, thanks for having me again, Scott. My name is Ashley Ward, and I am in the Baltimore office, but I do represent clients all throughout the state of Maryland. I've been practicing family law for about 8 years and been with the firm for 4.
Thanks, Ashley. And rounding out our panel today from Belleville, Illinois, let's welcome Krista Jones-May. Welcome.
My name is Krista Jones-May, and I am out of the Belleville office. I'm an associate attorney there. I've been practicing in Illinois since 2019, exclusively practicing family law.
Thanks for joining. Well, that rounds out our panel today. As you know, today we're going to talk about taking action and advancing your case. The frustrations many guys have around the country is that, courts, they're not open for in-person hearings. They're slow. Things are becoming backlogged. The idea around the country is you just have to wait. Well, we're going to talk about that and knowing that you can take action and not wait. There are many ways to do it. We're going to talk a lot about that and go through with our panel their collective experience and what they can do moving forward. So, but before we get to that, we're going to take a very quick break and we'll be right back.
For some dads out there, the coronavirus pandemic has become a pretext to limit access to their children. Other dads have been pushed out of key decisions affecting their children's lives. If you're one of those dads, Cordell and Cordell is here for you, as always, but with expanded services. We can meet you in person or by video conference on weekdays, evenings, or weekends. Our goal is to step up our service to meet your needs now.
All right, welcome back. So let's talk a little bit about what guys can do out there. You're either filed or you're not filed and you're trying to make that determination. But interestingly, if you've been looking through the news, avoiding a lot of the white noise out there about things going around the country, and you focus just on divorce, really, there's been a lot of articles, particularly in ABC News, talked about weekend divorce, which is a really interesting topic and caught my eye. And in that article, if you want to go ahead and Google it, it is really interesting. There's a video about weekend divorce and what that really meant. So I found it interesting. I want to open it up to the panel, but particularly Tally, I want to talk to you and let you start with you about this weekend divorce idea and really talking about it. And I think what interested me most, and we're going to talk a little bit about this and how to move things forward, but utilizing mediation as a potential way to get through it. But in this weekend divorce, to me, seemed perhaps almost somewhat going a little bit too far for some of the guys that we represent, because what it did is really puts them in a room. It says you go in on Friday, you're married, and you can be guaranteed on Sunday you walk out with an agreement. So what is your take on this ABC News weekend divorce article, Tally?
So in reviewing the article and thinking about it, mediation, I like to participate in mediation. I think it's a good way for clients to have a say in how their divorce or their parenting plan goes. I think it's an excellent idea. Now, the issue is, what I don't know about this is how much preparation goes into this. So generally settlement can, takes quite a while, even a couple weeks, couple months, because you do want to really think about the decisions. What impact does this have on me, my finances, my children? And so, it could be a little bit concerning if you agree on something. And what I don't want clients to do is get buyer's remorse. So you do want to have a lot of time to think about, the decisions that you're making, what's most important to you. So just generally overall, I think, if you could get it done in a weekend, maybe on very simplistic issues, generally speaking though, I'm thinking it will take more time. What I found also interesting about the ABC article is that 20% of couples seeking a divorce in 2020 have been married for 5 years or less. And so what struck me about that is that if they have children, they probably have little young children. So my recommendation would be to really thoroughly think out a parenting plan. A weekend might be too short, with lots of holidays and the communication schedules and the actual parenting schedule and what would work for the family. So I would just encourage those families to be really mindful of the decisions they're making and signing, knowing that the impact and the modification process could be, time consuming and expensive. And so especially with little kids, I recommend doing it right on the front end to save you guys, time and energy at the back end.
It's interesting. You think about it at first glance, I thought, what a great idea to put two people in the room and, they can't come out until they've reached an agreement. It's kind of like putting them in an octagon, two go in, one come out. But the point is, what I worry about for guys going into this is that they'll feel compelled or obligated, almost that, we were talking off camera, buyer's remorse. You feel like you have to. The way that this weekend divorce was set out is you go in on Saturday. If you can reach an agreement, great. If not, on Sunday, you have a trial, albeit an informal trial, utilizing this third-party mediator. It didn't explain whether or not you have attorneys present, which I imagine you'd have to. But as Tally mentioned, it could be so early in the case, you're not ready. You may not know exactly what's all there. You may not have enough that we'll talk about discovery today. You may not know what's in the bank account. You may not know what a business is worth. You may not know the real estate valuations. And here you're going into this weekend divorce. Why? Because you feel desperate. And I think it is. It's a little bit desperate. Maybe the cases that are down the road and ready to go to trial, but can't go to trial, maybe this is a great option. We'll talk about that. But I don't know, open it up to anyone else that has any comments on the panel about this weekend divorce article.
I would say, Scott, that I think it's a lofty goal to try to get things done in a weekend and get things done as quickly as possible. But I know in a lot of cases that I have, after the case has been pending for some time, guys will get to the point where, they just want to get this thing over with, just get it done, just to have it done. And sometimes we'll make some bad decisions. Well, this is kind of like the opposite of that. It's doing that on the front end by just wanting to get it over with and get a result. And I would just want to caution people that were of that mindset of doing like a weekend divorce, if that were even an option in Alabama, which is not, to just be sure that they're thinking through everything with their attorney, making sure that they're crossing all the T's, dotting all the I's, making sure that they're getting all the information that they need so that they do get a fair result at the end of the day and don't regret the decision that they've made to get things done quickly.
Yeah. I agree. I did a little bit of homework. These things aren't cheap. I saw some at 10 to 15,000. They put you up in this posh hotel in this really comfortable suite and the great conference room. It's a great idea. And I think to me, a very small percentage of cases would be in my mind, eligible, would I ever recommend it? I mean, there are just certain things that there's so many things that could go wrong. You're going to walk out perhaps in an area that you're just not comfortable with, but you've committed to. So it's almost, we'll talk about it, mediation. I'll use the word binding arbitration. If you've ever heard that, this is basically what it is you're committing to walk out no matter what the result. And I think it's a tough one, especially when guys just want to have their day in court. So I thought it was an interesting one. It's a good transition for us to go to our first topic. Ashley, I'm going to turn to you. And I think what's interesting is, trying to understand what the shutdown means for guys in their case and what do they do. And I think a great entree with this is the understanding, and I think you've talked about this, and that is not every case has to go to trial, right?
Correct. And it does lend itself to what we were just talking about with that article. Mediation is a great tool to try and chip away contested issues. It could be a complete agreement, which we like to call a global agreement. And in Maryland, we don't have weekend divorces, but we do have grounds for the divorce, which is called mutual consent, which if you have a global agreement in regards to property, custody, all aspects of the marriage and family, the court will give you a divorce without any wait time. So the fact that they're not accepting court dates doesn't change anything. You could have a virtual hearing in the matter of a month's time. And that could be really beneficial to parties who really don't have a lot of issues. Just because you may have some more issues, you can still do mediation just for certain parts. So maybe you're able to deal with the retirement, or maybe you're able to deal with the marital home. You can break down parts of your divorce, which will make the court able to handle your case easier because they won't have as many issues that are contested.
The mediation, I'm a big fan of, a lot of people say, can I hire or should I hire someone to mediate the case? And, a third party, I always recommend to my clients, look, I believe in mediation. We should do the informal. And that is use me. Your spouse will use their attorney. Let's get together, or let's do a Zoom. Let's talk about it. In fact, yesterday, most of the day I spent trying to informally mediate. We're trying to get this thing settled, albeit because it's a new case. They really want to get it done before the end of the year for personal reasons, and I get it. And so I think it's a good thing to consider that informal. You don't have the added expense of a third-party neutral. Your attorney can and will participate all the way along the way, and I think that's critical to give you the advice as you make the decisions, and it's not binding. I mean, that's the thing. If you, at the end of the day, you've reached a deal and you're like, I'm just really not comfortable. Okay, walk away.
Right.
I mean, that's the thing. So as you think about mediation, though, Ashley, there's got to be some preparation, right? You've got to have some discovery. I kind of alluded to that with my concerns about the weekend divorce. So maybe talk a little bit about the discovery process.
Absolutely. Discovery, to me, it's all about preparation, being proactive. You don't have to be in court to have discovery. That can continue despite what's happening in the court system. The whole idea of discovery is information gathering. Both parties can do it, and there's different ways in which you can do it. I like to break them down. So baseline discovery would be interrogatories, where you ask a certain list of questions to your spouse in regards to aspects of the divorce in the case. Then you actually ask for documents. We're talking about bank records. We're talking about employment records. We're talking about retirement. All types of documents that are pertinent to your case you can request, and they have to provide them to you unless they have some sort of reasonable objection. And then also, which is unique and not always used, you can have requests for admissions, where you give a whole line of facts and allegations in which the party has to admit or deny, and those are under oath, so they can be used in court. Those are baseline, but you can dig a little bit deeper. You can do depositions, and at this point, most deposition companies are actually allowing virtual depositions, so you don't have to go in front of anyone due to COVID. You can do subpoenas to bank records and employees, so you can get more information in that regard. And also, what I've started to like to do a lot is hire PIs to kind of do some observations and learn information while you're in this kind of no man's land of not being able to be in court. Those things can really help you, that when you're ready to actually present before the trial or present before the court, you have the information you need. And the beauty of discovery is there's an ongoing obligation to keep it up. So any type of updates that parties may have, they have an obligation to provide them to you. So you're constantly learning more information about your case.
The whole discovery process, I know the big complaint from clients is cost and expense, but the point is we want to make sure that it's the whole word. Let's discover what's out there. Let's make sure that we, one, know the item, what it's worth. that there are nothing out there that may be marital, or you may have a claim to that you otherwise don't know about, because they are, we'll dig and we want to properly advise you. It's often difficult when you're trying to distribute property to make sure that either it's an equal or disproportionate. Like yesterday, I'm trying to do a 70-30 split on property in our favor due to a number of reasons. But I needed to know what the values are. There's a car out there. I want to know what it's worth. What year is it? What mile? All this discovery. There's pensions. So I don't want to, gloss over the importance of discovery, because it is huge. And I think it's critical to have. If you're going to walk into either a mediation or this weekend divorce, be equipped. It's an instruction manual. If you're buying something for the first time, I'll pick something that's easy. A drone. You've never flown a drone before. You can't figure out how to operate, the remote control. You're going to read the instruction manual. You're just not going to give it a try because you invest a lot of money in a drone. Believe me, I'm speaking from experience, where I decided to fly a drone into the ground without reading the instruction manual. That was costly because I thought I knew what I was doing. So the point is do discovery, read the instruction manual, get everything you can. So Ashley, let's talk a little bit about moving forward, temporary hearings, motions, things that guys can do right now, albeit the courts may not have a full-blown trial. Are you seeing opportunities to have these temporary hearings, motions regarding custody, financial, and otherwise?
Absolutely. So in Baltimore, actually in the state of Maryland, they've changed the phase. We have different phases for opening up the courts due to the coronavirus. And we're now in phase 3, which is only allowing emergency hearings and temporary hearings of a certain nature. And so although the courts aren't open completely, depending on the details of your case, there are things in which you can file so that the court can respond to them. So we have expedited hearings or temporary hearings, and like I said before, emergency hearings. In Baltimore, we have a term, it sounds kind of scary, but blood on the walls, which means it has to be a true emergency. Someone's hurt for the court to have to come and make a determination about it. But in some counties, it's a little bit more lax. You would have to know in your jurisdiction what the court deems an emergency or deems necessary for a temporary hearing to be heard, especially in light of COVID.
Yeah, it's funny. I laugh when you said blood on the walls. I do that with my kids when they were younger. You'd hear them scream or cry, and I'm like, "Are you bleeding profusely?" And I use that word because if you're not, then don't bother me. And that's kind of the court's perspective is, hey, is this case bleeding profusely? Not a trickle, not a dribble, not something you could put a Band-Aid on, but is it bleeding profusely? And I think that's key. Now there are some instances where I'm sure we can push. And if we've got to be in there, that's why I always like to say we unapologetically step on toes. It is what it is. And I say, look, Judge, my client would like me to argue this. And, I'm sending a message that the client really wants this heard. So let me go to you, David. Thanks, Ashley. David, one of the things we think about in terms of moving the client or the case forward when courts are telling us, hey, trials aren't available. Like right now, St. Louis County is in phase 0, which means forget it. Nothing's happening unless it's an emergency. So are there things that questions guys should be asking? I know we alluded to discovery, the things that they should be thinking about as they want to move their case forward, particularly.
There's definitely things that you should be thinking about, and your attorney should be having discussions with you about that as well. Especially if there's going to be experts involved, anything like that. If there's going to be an accounting expert that's going to be evaluating the value of a business or different things, tracing accounting records and things like that, those processes can sometimes take 2 or 3 months or more on the short end, and sometimes they can take as many as 6 months. And so that should be something that the attorney should be talking with you early on so that you can make plans for that. And so that if and when this case does go to trial, that those things have already been done and we're not having delays based on those things. The other thing that you can do as far as moving things forward, we talked about mediation a little bit. That's one great way to try to resolve the case. Scott, I think you mentioned having settlement conference informally with the attorneys involved. That's a great way to accomplish the same thing that you might get done at a mediation, but also save some time and money because you're not having to involve a third party and additional attorney's fees and costs. But the main thing is to stay in contact with your attorney and make sure your attorney's staying in contact with you so that you can start to plan and create a roadmap as far as how to move the case forward. And that just because there may not be a court date that's looming or some kind of deadline that's on the court's calendar, there's things that the attorney and the client can do as far as to just keep the case moving forward and make sure that we're making progress while we're not able to get into court right away.
Yeah, I think it's important. Around the country, you're seeing now as expected, perhaps some waves of closures and restrictions, whether it be restaurants or, gatherings, groups of 10 or 8 or whatever it may be, the limitations that you see. And I think it's one of the things I like to tell the clients, and we'll talk about here today, is COVID, we don't want it to be convenient just to stop and do nothing, meaning that your case, and we're trying to get the message out that, look, we can move things forward. We can continue at a pace as if we were going to court, getting it ready so that when maybe perhaps we can have an in-person or a Zoom hearing, we are ready. It's not an excuse to just sit here and do nothing. It's not as if guys listening or watching right now, there's no help available. There is. But David, special master, I talked with, I think, Jonathan Wynn and Rosario, Jonathan in Utah and Rosario in California, about 10, 12 weeks ago about a special master. That's probably, I think, a really good idea. We've had our attorneys here in St. Louis do that. Talk a little bit about the use of a special master as a potential way to move things forward.
So in Birmingham specifically, while we're dealing with a lot of backlog and a lot of cases in court that judges simply don't have time to hear all the cases, we've got 4 judges in Birmingham that are hearing exclusively domestic relations cases. And there's hundreds of cases that are pending. So one option that we do have is getting a special master appointed, or a daily master is one thing that they refer to it here in Alabama. And that daily master can hear the case. It's a practicing attorney. They can hear the case. They can make decisions, give recommendations as to what should happen in the case based on the particular facts and circumstances. And you try the case over a temporary issue just like you would normally in front of a judge. And then once that daily master or special master has heard the case, they can then make recommendations to the judge. And if no one objects to those recommendations, it becomes a court order after 10 days. So that's one great way to get issues heard that maybe the parties cannot agree on, and they just need to get some feedback from the court or from a daily master to get some things done. And you still have the option to object. So I guess that's the drawback. But if it's a fair ruling and both parties are able to see that maybe I didn't get everything that I want, but my wife didn't get everything that she wanted either, then at least we're making progress on the case. And that's one thing that daily masters can really help out with.
I want to talk a little bit about private judges, which we've talked about and I've seen utilized here in my office in St. Louis. But before, make sure to submit your questions via the chat box or the Q&A. We want to address those here in the second half of our virtual town hall and get you answers live right here and right now. But David, talk about private judges and the utilization. There's some drawbacks in terms of cost, but it's very similar to the weekend divorce. So when your case is ready, and I think that's what we would say, use the big words, condition precedent. That's kind of the one thing that has to happen, is it has to be ready for the use of a private judge to actually hear a case, hear a trial. For example, in our building, we've had that done. We had a trial done in our conference room down on the first floor, and it's as if it was in the courtroom and it was binding. So you seeing that as well being utilized in Alabama?
Sure. We've got a statute in Alabama, and I know a lot of other states do as well, that give the parties an opportunity so they can actually hire a private judge if the docket or conditions don't permit an elected judge hearing the case. If they can agree, they can actually hire a private judge to hear their case. And the advantage to that is they can move forward at their own pace. If husband and wife are wanting to move forward very rapidly and the case is ready and attorneys have gotten everything prepared for trial, they don't have to wait on a judge with 10 other cases in line in front of them. They can work together with the private judge that they've selected to move the case forward. The big issue here is whether resources permit that, and whether you kind of have to do a cost-benefit analysis to determine, whether moving things forward expeditiously, whether that's worth hiring a private judge, because they're not cheap. They're going to basically be charging similar rates to what your attorney is charging. And that's a third attorney that's involved. And if there's multiple court appearances, it can really drive up costs. But if the resources are there available, it is a great way for husband and wife to work together and both keep the case moving forward where it may not be possible to do so in the general court system.
Yeah. And, I think what's interesting which to me is it's something we didn't consider a lot in the use of these private judges prior to COVID, and how turning COVID into a positive is really, this is a great byproduct of it. And that is, For example, what I see the benefit to advise clients is I can find a judge, if the other side will agree, that we probably both know, both attorneys know, these are typically retired judges. We know what their rulings are typically like. For example, in Missouri, there's no calculator for spousal support. So we pretty much know if I'm going to pick someone I have in mind, I know the direction they're going to go. I can advise the client typically 90+% of the time, this is what's going to happen. You can look at joint custody. This judge likes joint custody. You know, this judge does this type of custody plan, or this is what they like to do when they go deviate from a child support chart. You know, in St. Louis, we have a slew of new judges. So trying to adequately advise clients as to what their expectations should be is sometimes difficult. So I think this is a great, result and benefit of using a judge that pretty much, if you do family law and the other attorney does as well, we're both going to be able to advise the clients as to what to expect and whether or not best case, worst case scenario, what you really should do. And I think that's a really good use of time. And as you mentioned, that the cost benefit analysis, yes, it does drive up cost, but sometimes you're looking at this point, I would anticipate some trials getting filed now. You're probably into 2022, which is shocking. When I first started practice, gosh, it's been, almost 28 years. It was not unusual to go 3 years for a trial for divorce, which is crazy. Then over the course of time, St. Louis general area went to no more than 8 to 10 months, which was an amazing, advancement in terms of getting clients and kind of some relief. We're right back to where I started to almost 28 years ago, and it's crazy. So, I think that's something to consider. Have that conversation. Again, this is the whole point of the virtual town hall, is to kind of give you some ideas, some tips, to kind of advance a conversation, encourage you to have a conversation with your attorney. If you don't have one, find one. So, David, thanks. Tally, I want to go to you. And again, remind everyone that's watching, submit your questions right now. We have a few via chat as well, the Q&A section. We're going to get to those here in a little bit as we continue to roll through how we advance your case, the best way to do it. So Tally, we all now using Zoom, or we're using some other form of media that to communicate. And so I think we look at that. How do judges and attorneys, how are they dealing with these virtual proceedings, and what is the kind of the recommendations you have for guys right now that are watching? First and foremost, to me, that comes to mind is dress appropriately, right?
Mm-hmm. Always dress appropriate when you go to court. Take it serious. Whether it's I actually tell my clients what kind of color shirt to wear, so they come up as soft in the court. You want to put your best foot forward. So you do want to shave, look like you, at least from the top, like top up, obviously, if it's virtual. Make sure that you take it serious though. And I think the judges will look at you and take you more serious if you took it serious. So if you're wearing a t-shirt or you're wearing something inappropriate, the court's going to know that you weren't really prepared. And so kind of along that same note, you do want to be prepared for your Zoom or your go-to hearings. And it's pretty obvious when you're not. So I recommend to my clients, and I practice with them a day or two before, do you know what the technology is? Have you used it? Where will you be when this happens? Who's around you? Is your dog, there's an opposing counsel that keeps having his dog come into trials and hearings here, which I just can't believe, but his dog walks in and he thinks it's no big deal. So, that has to make some impact, I think, in the court, and whether or not they're taking it serious. So the Maricopa County, they've done an excellent job. So we're actually not as delayed as it sounds like people are across the country. So we are really focused on, getting into court quick, but it's all virtual still. Some things are being set out in person in the new year, but I expect those to be transferred back to GoTo or to Zoom. So some other just tips: know how to use your mute button. Right? Know who's around you. Some people that seems to be the biggest issues when I have the judge saying, "Hey, Mr. Whoever," and he's saying something and he's on mute. So make sure to use the basics, and then preparation, especially if you have a trial with exhibits. So a lot of our exhibits right now, we're able to do it all electronically. And that's a whole new technology for all of us, right? I didn't think in February that we'd be here now doing Zoom trials still. This is a whole new world. So we're all learning it. But again, if you're prepared, you practice with your attorney, hey, page 7, line whatever, it'll make it all go a lot more smooth.
You know, in terms of, you think about, I love, again, the dress up part and trying to make sure you play the part. We've all probably seen on the news, and those have been, you know, the newscasters or the people doing a Zoom, they have a shirt, but they're not wearing pants, you know, and they don't realize, you know, what part of this video is catching on there. And I stand up and, you know, lo and behold, look, judges won. There was an article in Florida that the judge said, look, I want you to take this as seriously as the case that you want me to take this as seriously, right? And because you're talking about everything you've earned, all the things that you own, your kids, your property, your money, be serious. And that is dress serious. So you're going to play the part, but be careful. Have that conversation about what you should wear. Like, I had a client one time, he was trying to claim that he didn't have the money to provide spousal support in the amount. So instead of dressing, you know, business casual, he decided to wear like he's mowing the lawn, and the judge did not like it. And I get it. And you just have to be careful. Have that conversation. When representing guys, I say it's about appearance and preparation. How do you look? How do you sound? Right. Yeah. And so I think that's also, you mentioned practice, be prepared. I think that's also key. Go through your testimony, right? Go through the exhibits, know them back and forth, just like you were taking an exam in college or in high school. Prepare. Isn't that the best piece of advice?
Absolutely. And so some clients too, so I do have some clients still that like paper copies. So we'll make them a full trial notebook, just like we were actually in trial back in the day, right? So we're actually physically there, so he can flip through it, and then he doesn't have to worry about fumbling in his technology. He can actually have it with him right there. So that's been really successful too, especially those clients that are not quite sure about the technology, or they just want, you know, an extra little piece to make sure that they feel comfortable. So if your client feels comfortable in their trial and their hearing, again, I think that's gonna weigh heavily on the courts, and the judges are gonna, you want them to listen to you and not, you know, you want them to pay attention to what you're saying. So
yeah, I mean, we've seen, I mean, the Zoom technology, I mean, it's brought a whole new world of connection and connectivity and relationships to us. And, you know, you've seen the ones where, as you mentioned, be aware of what's in the background, what you can hear, what you can see. I mean, don't leave a vodka bottle sitting in the background, whatever, all the empty beer cans, or gosh forbid, you know, drugs or whatever. I don't care if it's legal. And look, it's all about doing a test run, you know, and making sure that everything's going the best way it can. So it just, we tend to jump quickly onto technology and make some, you know, maybe unreasonable assumptions that it's working well for us, when in reality it's probably working against us. So Tally, good stuff. Krista, let's go to you. You know, in the 10 stupidest mistakes seminar that I've done, I used to do those in person, obviously, and I still do some of them. We talk about it. We've done a virtual town hall on them, broken that into 5. One of them is always, you know, failing to file first. And there's guys out there right now, they may have not filed, and they don't know what to do because they don't know what's going on in the court system, what can be done. Why bother filing if nothing's going to happen? Why do I give my lawyer money if they can't do anything other than file this piece of paper? So I guess the question becomes timing. So what should guys think about, Krista, in terms of timing? What should influence their decisions on whether to file or not?
I think that the biggest thing that people should focus on right now is that we are seeing a big uptick in COVID cases, which is making a lot of the courthouses go back to some of the scheduling limits that were being used when we first experienced this COVID issue in March or so. So I know that the 2 counties that are closest to me right now have closed their doors to non-employees, which is resulting in a lot of continuances, which means that if you have not filed yet, you are looking pretty far into the future as to when you may get your first court date. Typically before COVID, we were seeing those first court dates happen probably about 30 to 45 days after the opposing party was served once you file your case. Now that's being pushed back. One of the counties is more 45 to 60 days, but one of the counties is, we're seeing some schedulings that are 90 plus days out.
Wow.
So the sooner you can get in, the sooner you can get filed, the sooner you can get queued up to get on the court's docket, and the sooner you can get to a resolution in your case.
Yeah. I think some of the things we also talk about is this a financial benefit? Is this going to help you by filing now? Back in the recession in the early 2000s, the Wall Street Journal was doing an interview with me, and they said, your guys can't afford to file, can they? Because they're unemployed and they don't have the money. And I said, they can't afford not to file. And that is, don't you agree? I think looking at the situation, maybe your overtime is at its lowest point. You're not getting any. Maybe your bonuses are cut off. And this is a good decision, a good time to really have a court analyze your financial situation and hopefully convince a judge that, this isn't going to change. There are many guys, think about it. We are at 13, 14 million unemployed. The unemployment rate, we just had another 740,000 new applications for unemployment this week. It's not good. St. Louis area, all the restaurants are shut. Some of these places are never going to open again. That may be the best time for something to move forward, don't you think?
Yeah, that's absolutely true. And also in respect to the specific issue of timing,
Mm-hmm.
If you are expecting that you may have to pay some sort of maintenance or spousal support, you are looking at a time period that's related to the date that you were married, and most likely, especially here in Illinois, you're looking at the date that you file for your divorce. So the sooner you file, the sooner you can cut off that date when you stop having to pay for maintenance. And especially if you are around that 5-year mark or just below it, that tends to be a pretty significant time in courts' minds where they are extending the period that you have to pay maintenance to your spouse. So if you are 6 months to 5 years, then the sooner you file, you may be able to miss that cutoff date and lower the amount of time that you will pay maintenance.
Yeah, there's so many factors. If you're the guy that may be paying and your spouse is employed, time is not your friend at this point. In the event that business shuts down, they become unemployed and unemployable. It also then increases the cost and expense. You're going to have to hire an expert, a vocational expert, just so many factors. Whether you own a business, let's say you own a restaurant, what's going on with that? Is this a good time to file because now you can't serve? It really, there's so many factors, but then that's not even talking about custody. Custody is a factor, Krista, right? And when you're thinking about timing and, what do you have and what is the schedule been? And is this a good time to move forward or wait? So what would you say with regards to custody timing?
Custody timing, I'm always an advocate for the sooner you file, the better off you're going to be. Once again, the sooner you file, the sooner we can get some temporary orders, or if everything works out perfectly in your case and you can work out the weekend divorce or just a couple of days in an agreement type of situation, the sooner you get something in writing, the sooner you are protecting yourself and your rights to your child. I can't tell you how many clients we have that come to us because they're not able to see their kid because of something the opposing party is doing. Once you have an order in place, it's much easier to get the court to reprimand that other person who is keeping you from your child. So you got to get in, you got to come in and get something filed and get an order, because it's protecting you in the long run.
Yeah. In the previous virtual town halls that we've talked about, guys are questioning and sending in questions. Hey, I'm not seeing them. They're denying me because of COVID when there's no one positive. And, that's when time, of course, you have to do something. That's a timing decision. You've got to either get filed, get some action, enforce your rights, don't delay. There's so many instances for guys, you've lost your job, but you mentioned, support continues to rack up. This is why it's important to have that conversation with your attorney. Just discuss strategy. What is the right timing? I'm a big advocate and I always caution my clients that are, my consultations. Look, I'm a big advocate of filing first, strategically, at least in the areas I'm licensed in Missouri, Illinois, and Georgia. And for me, it's strategic, but it's only if your marriage is irretrievably broken. And so that's a conversation you should have. Is I like to file first because I like to go first. I like to make sure. So let's go on. Let's get to the questions and answers. I know in the lightning round, people are sending in their questions as we go. So I wanted to remind you, send those in right now in the chat section or the Q&A. We want to get to those. And so we're going to leave ourselves about 15 minutes or so to get to some of those questions. So let's just go right now, right to the questions. So I've got one. I'm going to go to Ashley. Ashley, Bobby K from SoCal has a question about recording. Recording in your own home. You know, recording someone, is it illegal if it's to protect yourself from a violent boyfriend that your wife has an affair with? And that's kind of a general question. I know it's going to matter. Each state may have some different rules as it relates to recording. And I talked a little bit about that in my podcast today about that. But what do you say to Bobby about recording someone in their home, whether it be audio or video?
In Maryland, it does depend on specifically if you're letting the person know. So, and then also the fact that it's in the person's house, you have a right to do kind of what you want to do. If you think about security cameras, they're in your home and they're recording. However, typically what is advised in Maryland is that you're informing whomever you're recording, or you're putting signs up that there is audio recording, there is visual recording. So that person's put on notice, so that if there was something to happen and you need to file something for your protection, you would still be able to use that evidence. It wouldn't be excluded to do some sort of evidentiary rule.
Yeah, and Bobby was wondering, you know, about maybe recording in your car or common property. And here's the kind of thing that I always say, Bobby, is, you know, there is this one consent rule where you need to be a party to the conversation. You can't attach it to landlines. You can't put a recording device on the phone. But if you're present and they know you're present, you're engaged in that conversation, typically, at least where I'm licensed, that's acceptable. You just have to be very careful about doing something like that, because judges do get turned off by some of that, right? And I always say it's got to be the smell test. If you're going to get the evidence and it smells and it sounds really, really bad, then it's probably an okay idea to record when you're part of that conversation. It's much better to engage in a text conversation and get someone. But, you know, I know to protect yourself, if you're engaged with someone, meaning engaged in a conversation, or maybe it's a confrontation, you've got your iPhone, you've got your Android, whatever it may be, and you can hit that record button if it's lawful. I encourage you to seek out someone in California. Of course, we have offices throughout California to find out whether or not the best course of action. But, you know, video is the same way. You just got to be very careful about crossing over into the wiretap portion of where it becomes very legal and very criminal. And I can tell you from experience, I've seen clients being prosecuted for it. So, Bobby, just, you know, proceed cautiously when you're doing so. So next question, let's go to Krista. Krista, let's talk about Connor in Florida. How much should I be speaking with my ex and our kids about our divorce? That's a kind of a general question. What should Connor be doing, and how often, and should Connor be engaged in speaking with his ex about the divorce and everything like that?
I'm of the opinion that it does help to try and talk with your opposing party, your spouse, in the divorce process about what expectations that you both have. If you know what they're expecting, you know how to prepare for it. And all family cases are all about preparation. So if you know what they're expecting, that's awesome. You can give your attorney a heads up and you guys can discuss how to either get ahead of whatever issue that they're alleging, or how to come to a resolution on those problems. As far as involving the children in these conversations, I would say keep that to a minimum as much as possible, especially if you have younger children. Younger children don't need to be exposed to adult conversations as much as is possible. And if it comes out that you are the person who's trying to either coach the children or get them involved too much, then the courts typically frown upon that.
Yeah.
On the other hand, if you have a 16 or a 17-year-old child, then they're probably going to have some opinions about the divorce and who they may want to live with primarily. And in those instances, I would think that it would be more appropriate for you to discuss with them, and potentially even with your spouse, just sit down with the three of you or however many children that you have and say, listen, we want to get your opinion on this.
Mm-hmm.
Want to do, or what would you prefer?
Yeah, so Connor, I agree wholeheartedly. And the thing that and it's one of the mistakes guys make when facing divorce in the seminar that we've done, and it's talking too much. And so where you cross the line is when you start talking trial strategy. the things that you shared with your attorney about hiring an expert, what evidence you're going to present. If you're going to have these communications, it doesn't mean cut off all. What it means is you need to have continuing communications with your spouse or your soon-to-be ex about all things related to health, education, welfare, and custody exchanges. That's not sharing too much. That's perfect. You want to continue that line because you're going to be co-parenting in that regard for quite a while moving forward. Just don't cross over into what you and your attorney have planned. Don't talk about the divorce in general. Just be a parent. Again, as Krista suggests, don't include the kids. It's just never appropriate. You don't want to get into a parental alienation situation. So I think that's kind of what I would do is it doesn't damage your case to do any of those things, in terms of health, education, welfare, but it does when you talk strategy. I've always given an example where my client let slip that we had hired an expert that they hadn't known about, and that really damaged the case. So just don't talk strategy. It's like playing Texas Hold'em. That's the example I give in my seminars. If you've got two aces, you're not going to flop them over before anyone's bet because you want to win the pot. You don't want to share that. So don't share strategy. All right, so let's go to Tom in Columbus. Let's go to David real quickly. David, can a PFA order be appealed? And I think Tom is referring to protection from abuse, or order protection. And I know he's talking about Ohio particularly, but you can talk about Alabama, and then the other panelists can always chime in if needed.
So with PFAs, these are really tough situations a lot of times. And if a PFA has been filed, generally, a lot of times what I try to do is try to not have that hearing if we can at all avoid it. We want to try to, especially if there's any truthfulness to it, we want to try to keep that evidence out of the court. We don't want testimony involved. Sometimes there's a lot of times criminal implications that could come along with that PFA, and we don't want there to be a record that can then be used against the client later. As far as appealing a PFA, again, if there's a possibility to make agreements, like a lot of times these PFAs are accompanying a divorce or a child custody matter or something like that. And if there's a possibility to make an agreement so that there is never a PFA adjudication, there's never an order that gets entered that requires it can't come within 300 feet of this person, or you can't have any contact not only with the spouse, but also with the home. It creates all these contemporaneous issues and other problems that may or may not be spelled out specifically in the order, but can cause so many other issues along further down the line. It can create visitation issues. So the big thing that I try to do is, number one, make sure the PFA is not heard. See if you can get an order in the accompanying divorce that prevents some of the damage from occurring that could occur. But if you do have that hearing and for whatever reason you've determined that moving forward and having a hearing and you get an adverse result, yes, there is a possibility to appeal. But first and foremost, I think that's a conversation that you definitely want to have very much in detail with your attorney. Don't ever have that hearing without talking to an attorney first. I have so many clients that come to me that have had a PFA hearing and they come after the fact. So that's something that you want to talk out very carefully and strategize with your attorney before it happens.
Yeah, agreed. PFA's orders of protection, they're won and lost based upon what's in the petition originally. For example, here in Missouri, harassment has to be more than one instance. So that's always something I'm looking for. Someone may say he harassed me, but the only thing they plead is one instance of showing up and then leaving. And so those are the kinds of things I think what you want to look at, Thomas, is to have an attorney take a look at what's in the record, what the pleadings are, what happened at that hearing, and see if there's room. But typically they are appealable. They are, as long as they're a final order. Every state will determine what is a final appealable order. There's some words that they use called interlocutory. So you just got to check, and I think it's worth it. And there are timelines. So I would encourage you. There are very, very tight timelines to appeal. Don't know what that is in Ohio, but I would encourage you to reach out to an attorney right now and find out what those rules are. So let's go to Ashley. And I can also answer this because I think this was something I mentioned. RHL asks, is the retirement split dependent on when you file? In other words, is that balance at filing used for the split, so like the value of maybe a retirement account. And so let me mention this because I know that we talked about this and I was surprised, and I can't remember the state particularly and don't know where RHL is, but here in Missouri, for example, the date of filing does not impact the date of valuation. So the date of valuation in RHL says Arkansas. So I don't know, and it might be. But for example, we file, it's as of the date of divorce is when our retirement accounts are valued. I know there are other states, it's date of filing particularly, which I was just very intrigued by because that, again, filing first, filing timing, huge. But Ashley, what do you have in Baltimore? And maybe the other panelists can chime in as well for RHL.
In Baltimore, it's the same as Missouri, so it's at the date of divorce. But it should be noted that parties will look at the account and make sure there's no what's called dissipation. So if you're trying to take out loans or just do withdrawals on your account during the divorce, that could hurt you if that's being used for things such as buying gifts for other people or just doing different things. It could affect the amount that the other person gets in terms of distribution. But typically it's at the day of divorce.
Let me go to you, Tally. What's going on in Arizona? What are the rules with regards to Arizona?
So we're the date of service, that's our valuation date. So when you're actually officially served, although it is subject to natural gains and losses. So to our point earlier, if you're divorced in some of these other places, can take a year or two, one party could still be contributing to that 401k. And so here, the contributing spouse is still entitled to that portion that they're continuing to contribute after that date of service. So anything you accumulate after that point is still your sole and separate property. But we will take into consideration the natural net gains and losses. So as we know, the market goes up and down naturally. So it's going to be that we're going to look at that value on the date of service, and then either the actuary or the person who does the quadro will figure those dollars out.
Yep. Illinois for you, Krista.
We are also date of divorce. So, but I've also seen it done that we can choose a valuation date. So if we have a trial that's set in May of 2021, sometimes we decide between the parties, December 31st may be the cutoff date. So, but it's date of divorce.
And I think that's probably the common one. Alabama for you, David. What's the date of valuation?
Date of divorce as well for Alabama. And just to piggyback on what Krista is saying, we can also negotiate and attempt to try to get the best retirement division possible for the client by taking into consideration when the divorce was filed, look at gains and losses, whether we can try to strategize to benefit the client a little bit. The other important thing to keep in mind is that the only thing that the court has authority to divide as it comes to retirement are those contributions that were made during marriage. So premarital contributions, even though maybe there's a $500,000 retirement account, if there was $100,000 that was contributed in pre-marriage, not only is that $100,000 not marital property, but all the earnings on those $100,000, typically it may be a lot, especially if it's a 20-year marriage. So that's something to keep in mind, that premarital contributions are not divisible in Alabama, at least.
Yeah. So RHL, I would have you go consult with an attorney. We have an office in Little Rock. I don't know where you are, but obviously the data valuation is key. And I know there are states out there, as we've talked a little bit about, that it's big data filing. So that's huge, especially with a market that's taking off and it's peak right now. But you got to think about timing and gains and losses. So I encourage you to get some advice on that. So let me go to you, Tally, real quickly. Teresa has more of a issue with an attorney who will not return calls or even acknowledge receipt of an email. The courts may not be fully open, but surely the attorneys are still operating. Obviously, this one's in Florida, but obviously I can mention it, but we can talk about the Cordell policy. Mm-hmm. that all attorneys should be following, and I don't know why they don't, because my experience, and I'll share that after you comment, Tally, mm-hmm. and talk to Teresa.
Yeah, so our goal is to respond to all communication, so phone or email, same day, if not, the next day, every once in a while. But I try to respond same day. A lot of times just to take the stress out of clients. So if you're not getting a response from your attorney, then you could reach out and try to set up a meeting. You could reach out to their paralegal. Maybe there's another attorney in that office you could communicate with. I don't have those communication issues. So if that attorney's not responding, maybe they're not a fit for you, or maybe they're on vacation and they forgot to put their away message up. I'm not really sure.
Yeah. I mean, it's so frustrating. I get it, Teresa.
Yeah.
I think it is. We have the same issue for our own business attorneys where I think
Mhm.
I just answer my question. You
Mhm.
return my email. Tell me where you are. Tell me you're unavailable and when you can get back to me. And we live in a world where, I think law firms have gotten away from focusing on customer service and making sure that understanding that divorce doesn't end at 5 p.m. You're still living with the frustration and maybe sleepless nights. So don't stand up for, don't accept it. It's not acceptable behavior. It shouldn't continue. Unfortunately, and maybe it just isn't a good fit because it's not meeting your needs. And so you need to find a lawyer, just like you find a doctor. I always talk about this, someone you trust inherently, who looks out for your best interest, that responds to you timely, communicates with you often, and keeps you advised of what's going on. I think those are the key things when you're looking for someone. Obviously, we have offices throughout Florida, so happy to help if we could. But I'd say at all efforts, try to reach out one more time and see if they'll return your call. And if not, then it's time to move on. You can't wait. So good luck, Teresa, and I hope we can help you. Let's go to Krista. This is Dave in Iowa has a question that Dave's daughter is 15. He thinks that she's much more comfortable at his house. At my ex's home, she's quarantining with my ex's new partner, who she does not know very well. He'd like to change the living arrangement where she lives more with Dave on the weekends, but not sure how it will go during COVID. Question from Dave is, one, can his 15-year-old have some say, and is this even possible to perhaps modify a living arrangement in the middle of a case?
Yes, you can modify. If it's a temporary order, those can be modified. You do have to file the appropriate pleadings for that to happen, of course. As far as whether your daughter is going to have a say, that is very court specific. Sometimes courts don't like to talk to the children until a final trial or as late as they can possibly get it. But with her being 15 years old, it is much more likely that they will consider what she wants. It won't be the only thing that they consider, but it would be appropriate at her age for the court to consider her.
Yeah. Agree. In Georgia, I know that at certain age, particularly when I was practicing there a number of years ago, at certain age levels, the input of a child, absent showing that it's a coerced or unintelligent, representation, it's mandatory. The court has to follow it, absent some sort of facts. It suggests that, either the parent influenced it or the particular reasons why they want to spend time are not appropriate. But I think, in this case, when we're looking at, it's Iowa, obviously we have an office in Des Moines and Council Bluffs. So I think it's not that the court has to follow, but if you look at the custody, most custody statutes around the country, the choice of the custodial parent by a child is to be considered. It's just not absolute in most states, but typically you'll see it, for example, in Missouri, I think it's number 8 on the list. So it means the court's going to go all through the first 7 before it even gets to the choice and concerns of the child, because they'd rather not involve the child unless absolutely necessary. But in a teenager at 15, here's the thing. Judges know it. If you've had kids, not much you're going to do with a teenager. If they say they're not going to go or they're going to go. They're going whether you tell them or not. And so I think that's something, Dave, you should consider, having that conversation with your attorney about the best way to approach it in a temporary motion, and you can get through that. Let's see. Let me ask, Scott's got a question, and I'll just toss this to Tally. Scott just wants to know, not me, basic divorce fees for Cordell. Does our firm work on a contingency basis? And I think those are, we don't have to get specific about our fees, but you can talk about contingency, which obviously is an easy question.
Yeah, no, we don't do contingency fee work. Some states allow it, but it's very, very limited. We don't do that here. So all of our offices have fee agreements, obviously, and have initial deposit options. And there's a couple different options in most states here. So we bill on an hourly basis, though. So we account for every 10th of an hour for the work that's done. So you're going to be, your attorney, if you decide to retain us, will have an hourly rate. And then you're billed on the work that they do. So if they're just hanging out, it's obviously they're not doing work. It's, they're not going to charge you. If they're doing work, drafting, going to court, then you'll be charged for the work that's actually done in those increments. And so one of the great things about Cordell is that you'll have a client portal. So you can actually see what your billing is as we go. So there won't be any surprises. And then You will get your bill every 2 weeks, so you'll have, constant communication about what's going on that way.
Yeah. And I think I could say for all of the states throughout the country, that the contingency fees for divorce is just not allowed ethically. I would say that's probably right. It's just prohibitive, and attorneys can't do it. And if they try to do it, it's probably not allowed, and they're acting against the rules of professional conduct. And I think it's important because you want to make sure you don't have an interest in moving the divorce forward. And it is simply hourly, and I think that's the best way to have that fee transparency, to understand what the rate's going to be, the client portal that's offered, understanding how much is going to be charged. So I think that's important. So Ashley, I'm going to go to you as the final question for the day in our virtual town hall. And this is from Ted in Connecticut. Ted wants to know if there are any specific defensive acts, methods that he should expect from my spouse as a dad fighting for split of custody of my kids. Anything that Ted can prepare himself as he's really trying to get a 50-50 split in custody. What should he be looking for from his spouse that she may try to do, or what should he be doing just to kind of help advance his case in equal custody?
I know in Maryland, status quo is a really big thing that they look at in terms of the factors for custody. So if they don't actually have an order yet, try and set up a schedule sooner than not is really necessary for them to have some sort of 50-50 schedule. Even if he doesn't have the actual 50-50, the more time he has, the more likely they can add on to it. So something that he would probably need to prepare for is her controlling that and trying not to allow him to have as much time to be able to go to court and say, this is what's been happening, we should continue the status quo. I think it was said earlier that that's probably why you should make sure you're having communication in writing about trying to create a schedule and access and show that it's not that it's an agreed upon schedule, but it's actually being denied. I have clients a lot, I tell them to be wary of protective orders. That could happen during exchanges, especially if there's a lot of issues in terms of how the parties are getting together, because in Maryland, custody can be determined temporarily through a protective order, and that can follow you through your case in terms of a divorce or custody matter. So if you think that that's something that your wife may do, then I would encourage you to have people come with you to exchanges, or even be on the phone with someone. So if something was to happen, you would have a witness. It wouldn't be a he said, she said thing. Lastly, in terms of preparation, I would tell clients, think of your case as a Jenga game. And each little piece are allegations that your wife may say. And what you want to do is weaken her piece by taking out those pieces. So if you know there's certain things that she might say about you, maybe they'll say that you have an alcohol problem. Stop drinking. Maybe they think that you have some sort of anger problem. Make sure you're minding that. Or if you have any type of medication, make sure you're up to date on that, so that when they try to do that for trial, you've already taken those pieces out. So they no longer can use them against you, because she will absolutely try.
Great advice, Ashley. And that does it for our virtual town hall for November. So thanks to our panel for giving great tips and educational ideas and tools and information to guys before, during, and after divorce. So continue to check us out on our weekly podcast that we do twice each week. We talk about topics, spend just 15 minutes or so talking about topics in a very quick manner. You can check that out. Go to CordellCordell.com. Check out our YouTube page where all of our materials sitting out there, and you can kind of look at our past virtual town halls and all of our podcasts as well. After listening to this town hall, you may have further questions. You could submit those to coronavirus.divorce@CordellLaw.com or schedule a consult by calling us at 866-DADS-LAW. Go to the web at CordellCordell.com. I'm sure we have an office near you, being across the United States. Until next time, have a great week.